Top 5 common PPP loan fraud schemes. Hi, I'm attorney Jason T. Brown. As a former legal advisor special agent with the FBI, I currently run the law firm Brown LLC. We have 20 plus people. We are ranked in Lex Machina as one of the top most prolific law firms under the False Claims Act, who litigates that particular statute. And consonant with that, that statute directly addresses violations of PPP loan fraud. So we do represent quite a few cases of PPP loan fraud on behalf of the whistleblower and vicariously through the U.S. government, relating as a relator through those False Claims Act lawsuits. Additionally, you may have seen my other videos. I am featured prolifically and quite a bit in various news sources. Most recently, I'm featured in a 30-something minute documentary about PPP loan fraud from an interesting journalist, and we're happy to provide the link below if you want to hear me. And also on that video is a billionaire, Peter Schiff, discussing the consequence and nature of PPP loan fraud. I want to go over a top 5 list that you don't want to be on and a list that maybe you do want to be on. And that top 5 list is how people have exploited and abused the PPP loan program at the expense of the taxpayers. And here are 5 of the most common schemes. The first is inflation. Inflation is when a company or entity exaggerates the amount of revenue it was making and or its employee count in order to receive more money than it was entitled to. For example, a company of 50 people putting in for 100 people. A company making 2 million revenue putting in for 4 million in revenue. If that's the case, it's just outright falsification of documents. It's inflation about the amount that the entity was entitled to, and it's a violation of the PPP loan standards. The second is deflation. Deflation, I think, is one of the more actionable cases under the False Claims Act. Deflation involves when companies had more than the 500 people and or 10 million in revenue and took money that was purposed for small businesses when in fact they're not a small business. One of the way that happens is, for example, if a company actually has 600 employees and just arbitrarily put down 500, so they weren't above the cap. The other sneaky way in which it happens is if the company and the nucleus of ownership owns several common interrelated companies and fail to disclose the interrelated companies. It would not have been eligible, but for the fact that it really lowered the amount of employees and revenue it claimed it had by isolating individual companies instead of the aggregate companies like the SBA requires you to do. And therefore, all the entities probably received loans that exceeded the $10 million cap, which may be a very fertile case under something called the False Claims Act, which really encourages whistleblowers with inside information to come forward and blow the whistle off these PPP loan fraud schemes. And I'll get into that in a second. But we're going to scheme number 3, which is ineligibility. There's a certain list of criteria in which companies at the outset were eligible for PPP loans and certain prohibitions. There's a lot of conditions that center around, for example, nonprofits. Nonprofits are eligible in certain circumstances and not in others. Ineligibility may center around the nature of the business. If it is, for example, a entity that's lawful in certain states like Vegas, where it is for lack of a better word, prostitution, where it's legal, that was not lawfully entitled to any PPP loan money. Marijuana dispensaries not entitled to PPP loan money. So for example, if there was a company that was the marijuana dispensary of Georgia, which I doubt exists, and if it does, it's incidental that I mentioned the name in the video, and they knew enough to know not to put in for a loan along those lines, but then instead called the business the MJ Happiness Corp, and instead put in for that and changed their NAICS code to falsely reflect the nature of their business to obtain a loan, that is another outright violation. A fourth violation is just the bust out schemes. And under the bust out schemes, here are entities that either just didn't exist and took the money and probably, unfortunately, will never be able to hold accountable. A lot of them were outside the country and using dummy shell corporations in the United States to bleed the US taxpayers dry. But the others that may be actionable are, there are a lot of people who are retired restaurant millionaires. And what they did was take PPP money, RESPA money, and other monies that were available, just fired everybody. That was not what the PPP loans were for. The PPP were supposed to be purpose so you didn't have to lay off or fire employees or even furlough them at times. So it's supposed to be purpose for the benefit of paying payroll for the most part. And if you took the money and ran, well, that's kind of a bust out scheme. And I think that's highly addressable under the False Claims Act, depending upon the amount that is in controversy. The fifth is what I think are bad banks. Bad banks doing bad things. And this may be a very fertile ground, although probably a lot of these cases have already been filed. But there are certain financial institutions that were handing out the money like candy and not doing due diligence. And when I say not doing due diligence, that's one thing. I mean, that's arguable whether that's willful scienter and misconduct and wrong conduct. But it's worse than that. They were willfully turning a blind eye to information they had at their disposal that showed the applicant had falsified their application. And for example, let's first take conceptually under bodies of law, there's a lot of KYC requirements of banks, which is know your client. So really, the PPP loans should have come through banks in which individuals or corporations had an existing banking relationship with. But sometimes it didn't. So if it didn't, you would think they would have scrutinized, but there are some mill shops, and some have been dinged already, that just blindly approved everything. But what if they did? And what if the bank had information at its disposal, or with a cursory examination could find out the company didn't have 400 employees and $8 million in revenue. It has 4 employees. It's in the janitor's closet and it's 4,000 in revenue. And they had that in a competing document at the facility. Well, the banks may be held liable for the PPP loan fraud jointly with the individual that had defrauded the federal government. I told you to also tell you that's the 5 lists that you don't want to be on, but the one thing that you do want to be on, and the potential thing that you definitely want to be on if you have inside information regarding PPP loan fraud, is the False Claims Act Whistleblower Program, which can entitle you to up to 25% to 30% of what the government recovers if the government recovers funds from PPP loan fraud. That's one thing our law firm, the Whistleblower law firm of Brown LLC, focuses on. You can call us for a free consultation, 877-561-0000, about this and or other type of whistleblower matters. But I do want to get into it just a little bit before you call us about some of the PPP loan fraud cases our firm doesn't handle. If it's a bust out scheme from another country and it's not collectible, it's just not something we can help with. You're welcome to contact the authorities, but we do love helping people. We do take cases pro bono, meaning we don't get paid at all at the end of the day. But at the end of the day, we still are a for-profit firm. We have great resources, but we're very focused on the cases we work with. Consequently, just the amount of damage is in play. It is rare for us to take a case unless there's many $1 million in play. Would we take a PPP loan fraud case that has $1 million of damages? Maybe, maybe not. But when you get below the $1 million, it's unfortunately below the threshold for our firm to handle. Also, there is always the ongoing debate, insider versus outsider. If you are a whistleblower from the inside, that information is much more coveted, particularly if you have the details of the scheme and the scam. If you're an outsider cobbling together publicly known information, at this juncture, I think even though some outsiders have been paid as PPP loan fraud whistleblowers, it's dubious unless you have great information that's not easily accessible in the public domain for us to be able to, at the end of the day, obtain a successful result for you. But we're always open to listening, particularly if you have access to certain databases that can bring the government's attention to the problem for the first time. But if it's just like, hey, I looked at ProPublica, found out how much money they took, and I looked online at something else and got it, it's probably at this point a little too late to start to file those types of cases. Once again, a PPP loan fraud, we didn't talk about its nature at the beginning, but it really hurts the taxpayers. This is an important cause. If you have information to obtain some modicum of justice, get the taxpayers back what they're owed, help yourself along the way for doing the right thing. So I thank you for listening. Check out our site, ifightforyourrights.com. And again, call us if you have any questions for a free confidential consultation about PPP loan fraud, 877-561-0000.